Hello, everyone. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I'm excited to be moderating today's webinar on advisory opinions as part of the site's continuing series dissecting and analyzing the debt collection rule from the Consumer Financial Protection Bureau. One of the interesting components of the debt collection rule was the inclusion of advisory opinions. Advisory opinions are guidance that's issued by the CFPB that will seek to answer specific questions about compliance issues or concerns about the debt collection rule. Today in this webinar being sponsored by TCN, we have a panel of leading executives from across the accounts receivable management industry who are here to talk about the impact that advisory opinions could have on adapting and complying with the debt collection rule. This is the fourth in a series of webinars aimed at analyzing the debt collection rule that was issued by the CFPB back in October. Each of the webinars in this series are being sponsored by TCN. Before I introduce the panel, I want to take a quick second and go through my spiel about accountsrecovery.net. For those of you who don't know what it is yet, accountsrecovery.net is a news and information website for the accounts receivable management industry. The site publishes unique and curated content, maintains a number of email newsletters, hosts webinars like this one, offers podcasts and videos, and manages a Slack channel, all for the ARM industry. All of that content is free for anyone in the industry to use, and I think combines to form a great resource of news and insights to help educate and inform. I hope you'll all spend a few minutes every day checking out what it has to offer. Now let me tell you a little bit about today's panelists. Dustin Alonso is a regulatory and financial services attorney at the law firm of Hinshaw and Culbertson. He advises clients on compliance with state and federal laws governing a variety of consumer financial products. He has experience handling both state enforcement actions and CFPB supervisory examinations, as well as counseling clients on Truth in Lending Act, Fair Debt Collection Practices Act, and Telephone Consumer Protection Act matters. Born and raised in New Orleans, Dustin helped establish the firm's New Orleans office there earlier this year. Patrick Newman is a shareholder in Bassford Remilly's Consumer Law Defense Practice Group. He's been involved with the credit collection industry in one form or another since he was 19. Now he represents industry members, helping them prevent and navigate disputes in federal and state trial court. He has extensive experience working closely with in-house counsel and financial services providers defending FDCPA, FCRA, and TCPA, and other consumer protection claims, including class actions. Brent Yarbrough is a principal with Maurice Wutcher. He primarily focuses his practice on regulatory compliance in the defense of consumer law claims. Brent has experience representing financial institutions, debt buyers, collection agencies, and law firms. He has defended numerous class actions and individual claims involving the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, the Telephone Consumer Protection Act, the Truth in Lending Act, and various state law claims asserted against lenders and their assignees. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them as our discussion is ongoing. To submit a question, please either enter it into the chat module or the Q&A tab on your Zoom webinar control panel. This event is being recorded, and a recording will be made available in the coming days on accountsrecovery.net. Since our panel is going to be talking about compliance today, let me read this following disclaimer on their behalf. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. With that, let's jump into our discussion. Dustin, Patrick, Brent, thank you so much for joining me today. Looking forward to hearing what you have to say on this important topic. Let's start with a very sort of basic question and start to drill down from there. But let's talk about what an advisory opinion is and why it matters. And Dustin, since this is your first webinar, we're going to give you the honor of going first.
All right, appreciate that. Thanks, Mike. I guess before diving into what an advisory opinion is today, let's take a second and look back, right? Because advisory opinions were contemplated by the original FDCPA back in the 70s. Provision of the FDCPA basically said debt collectors won't be liable if they rely in good faith with an advisory opinion submitted by, at that point, was the FTC, obviously now the CFPB. Now, when Reg F was finalized back in October around Halloween, there's an appendix to Reg F that actually picked up this advisory opinion concept, and they explained it a little bit more, but not much more, right? So under the advisory opinions, The language is any act done or admitted in good faith in conformity with an advisory opinion issued by the CFPB provides protection afforded under the FDCPA, and that's the protection for civil liability. So, you comply with an opinion in good faith, you have basically a safe harbor under the FDCPA. More importantly, and timely for Mike's webinar here, on November 30th, the CFPB issued a policy, the advisory opinions policy, which kind of drilled down into the process for either debt collectors, collection agencies, or anyone in the financial services industry to submit requests for an advisory opinion. And that can be done either through, as I think we'll talk about later, through the collection agency itself or the lawyer. So that's kind of the background. At a high level, I think Mike explained it perfectly. You have a question under whether Reg F or any other rules that are applicable to your business, you can submit an advisory opinion request via email, which is a more formalized process than what's currently available. When you do that, and I don't want to put the cart ahead of the horse here. When you do that, you have to submit a very detailed process, very fact specific, something that's directly applicable to your business, and where you have a question under some kind of regulatory scheme, Reg F, which is going to be effective next year. And you have to ask a specific question to the Bureau and propose a specific answer, and hopefully get an answer from the Bureau.
Excellent, thank you. Go ahead.
I think it's a great summary. And I would just add, so generally speaking, we've talked a little bit about the specifics of the FDCPA advisory opinions available through the Bureau, but just generally an advisory opinion from an administrative agency. These folks are, allegedly they're subject matter experts, right? So they should have the knowledge of the statute that you're subject to, and they can provide various forms of guidance to any stakeholder that's subject to the statute or the rule. And that's really what you're talking about with an advisory opinion. As Dustin was mentioning, here's my specific circumstance. We're in the middle of doing this, or we're thinking about doing this. Are we in compliance? And yes, so the FDCPA has this nice built-in, basically an affirmative defense to liability if you're relying in good faith on one of those advisory opinions. But it also matters just from a practical compliance standpoint, right? Is you can find out if a practice is good in the eyes of the regulators or not. And you can use that, even if it's not an affirmative defense, it's persuasive authority in a court. You can take that to a court and say, this has effectively been blessed by the regulators, so we shouldn't have an issue here. Or, if you have a sort of corollary issue that maybe wasn't directly addressed by an advisory opinion that was issued, you can at least say, well, look, here's how the Bureau thought this particular situation should have gone. I think you can extrapolate from that, in our case, why it should go in our favor. It just gives you a general idea of what topics are of interest, and it gives you a peek behind the curtain, right? What is the regulator thinking about right now? What is their line of thinking with a particular issue?
Dustin, you may have answered this, but I got a little foggy when you said I'd summarize something perfectly, because that's the first time I think anyone's ever said that before. So clearly this is your first time doing this. But I think I just want to go back if you didn't address it, but maybe if you do, or Brent, maybe you can handle this one. Who can request an advisory opinion? Is it anybody? Can I send an email to the CFPB and request an advisory opinion, or does it have to be someone specific or a company within the industry to do it?
Well, it's got to be. I'll take that. It's got to be made on behalf of an entity that's subject to the statute or the rule. But it can be done through a third party. I mean, specifically, they mentioned attorneys. So an attorney could send a request on behalf of a client. Another option is a trade association. So one of the trade associations in the industry can send a request for an advisory opinion on behalf of its members. If say one of us was sending one on behalf of a client, one of the things we're required to do is we do not have to tell the Bureau who our client is that's requesting the opinion, but we do have to certify that the client that's requesting the opinion is not subjected to CFPB enforcement. So they don't want to be trying to enforce something and then have the attorney go up, make an end run around to another group at the CFPB and say, hey, give us an opinion that says this is okay. But so there are some requirements around that. But yes, there are. It's not just limited under the policy that the Bureau just released that Dustin summarized earlier. That it does allow now third parties to make those requests, limited third parties.
So can I say I'm asking for a friend then?
Depends on who your friend is.
Yeah.
I'll have to, at some point, I'm probably gonna have to tell him who my friend is, I guess, right?
Well, you shouldn't have to give the name, but I don't know that, say, if you're doing so as, let's say that if a reporter, if someone in the media said, I cover the collection industry and I'd like to know if this is legal or not legal. I don't think that applies. I don't think that's a possibility, but maybe Dustin or Patrick can correct me on that.
All right, we've got our first question that's come in, so I'm gonna break from my script for a second and ask that. Use it as another reminder to everybody. If you have a question for our panel, type it into the chat or type it into the Q&A, and we'll get it asked and answered. And that question is: does that mean we can't share answers with other agencies? So can I ask a question and then share the answer with an agency that is under review by the CFPB?
That's easy. The CFPB will share it for you. These are all published.
So all advisory opinions, I think they're going to post them to they shared the page, I think, even, right, where they're posting the advisory opinions.
That's right.
And under they do, we'll post it, will be posted there.
That's right. And under Reg F2, any advisory opinions that are applicable to the FDCPA, they'll actually adjust the rule and put that advisory opinion into Reg F into either the rule or the commentary itself, or maybe the appendix where it is. So it'll be easy to find. But Mike, that also, I'm sorry.
Yeah,
that also brings up a good point though, because when I was reading through this, I was trying to figure out, well, how is this different than other tools that the CFPB has? Recently they have this compliance sandbox. They have no action letters that a few people have been taking advantage of, mostly banks. But they also have a lot of compliance guides that are posted on their website. And that's in the form of, it's more practical things. I enjoy using them. I enjoy sending them to clients because it takes this complicated rule and kind of distills it where, number one, I don't have to, and you see what the Bureau is thinking about their own rule. They also have something called, and I'm blanking on the name now, I think it's an RFI.
RIF, I think it is, but
RIF, exactly. And the way that works is there's an actual website for that, and you fill out a form on the Bureau's website, and you say, here's my name, here's my question, this is the statute or reg that I have a question about. So I was trying to figure out, well, how is that different than this advisory opinion policy? I think, and Brent and Patrick, correct me if I'm wrong, I think when you submit that is only applicable to you, and I don't think that's published. So I think what the Bureau is trying to do here with the formal advisory opinion policy is you submit it and the Bureau drafts this memo, which they did, the past 2 times, just last week or 2 weeks ago, that makes it public to everybody and could apply to more than one party who just submitted it.
Right, and that's, I think, what we're referring to is the regulatory inquiries function, which RFI, request for information, because that's really what it is, but RFI means something different in this context, of course, so that was already taken, but yeah.
Okay, excellent. Well, we've got a great start to our conversation and excited to see where it goes. But right now, I'm just going to hit the pause button briefly, and I'm going to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay.
Hi there. Thanks, Mike, and for everyone for attending and as well as participating. As Mike mentioned, my name is McKay Bird. I'm the marketing director here at TCN. And what TCN is we are a call center solution for both traditional contact centers, collection agencies, and as well as thousands of contact centers around the world. TCN has continually stayed current with the TCPA regulation and as well as the changes related to the CFPB by introducing these enhancements to our core platform. One of which is our TCN Natural Compliance, which uses smart algorithms to build compliance rules naturally. All you have to do is type a rule into the compliance manager, and the natural language compliance engine will build an easy to understand compliance rule, making managing your rules and as well as auditing those very simple. One example of a rule that you'd be able to implement is simply typing denying outbound calls before 8 a.m. and after 9 p.m. And really, you can really type any rule without any limit, and those rules will be processed in real time with our compliance engine. As well as those compliance features, TCN is a platform suite that also provides built-in data management that eliminates data entry errors, BI and reporting dashboards, call recording with storage, smart IVR and payment capabilities, speech analysis with transcription, and so much more. So regardless of your application, TCN can provide a robust solution for your call center and your collection agency. So I'd invite you for more information to visit our website at tcn.com for more information, and be sure to grab our latest copy of our CFPB summary ebook that will be debuting today. So head over to tcn.com for more information and to grab your copy. Thanks, Mike.
Excellent. Thank you, McKay. Really appreciate your continued support and your commitment to providing such great information to help educate the industry. And for those who are looking for a link, I put a link to TCN's website in the chat box so you can grab it there. We have another question that came in from our audience. So before I move on with my questions, wanted to ask that one. Going back to what we were talking about with the no action letters, someone asked if we could sort of go elaborate on the definition of a no action letter and maybe talk a little bit more about what it is and how it works. Does anyone want to tackle that one?
Yeah, I mean, I'll take it at a high level since I brought it up, and Patrick and Brent feel free to jump in. Essentially, it's another procedure that the CFPB has recently implemented where they allow an entity to submit a request where they outline their program. So the one that comes to mind, which happened just a few weeks ago, Bank of America submitted their new small dollar lending program where they'll make loans up to 36% under a variety of situations. They submitted that to the Bureau for sign off, and the Bureau signed off on that. And then they said, in signing off on it, the Bureau said, we're not going to take any action against you for the next, I think, 36 months under that exact program. So, you know, a lot of this is more applicable to front-end programs, obviously, especially fintechs who are trying to do something different. You can submit a program to the Bureau and get them to sign off, and then they won't bring enforcement action even, well, not if you're not doing something wrong, but if it complies with your request.
Excellent, thank you. Moving on, looking at going back to advisory opinions. Let's talk a little bit more about how it's different than a rule and sort of what the differences are between what they did with the debt collection rule and how an advisory opinion sort of fits in there. Patrick, would you mind starting us off on that one?
Not at all, thanks. So just fundamentally, it's different because a rule requires notice and comment, just like we had with this new Reg F edition, right? So there needs to be a proposed rule, and then stakeholders and the public need to be able to comment on it. Not so for an advisory opinion. More specifically, a rule is broad, right? So a rule is going to prescribe or prohibit certain conduct, give you certain requirements for how to behave, without actually getting into the factual specifics. But as Dustin, I think Brent both were talking about before, if you're going to make a request for an advisory opinion, you actually have to give very specific facts and allow the Bureau or whatever administrative agency you're dealing with to opine on the regulation applied to those specific facts, right? And so an analogy I'd give you is speed limit is 70 miles per hour. That's your rule. If you had the ability to ask for an advisory opinion from your municipality or your local highway patrol, what have you, you say, okay, it's 70, but can I exceed 70 if my wife is pregnant in the back seat and we're flying to the hospital, right? So that's basically what you're dealing with.
Okay, thank you. So there are concerns, at least from some in and outside the industry, that advisory opinions are going to create a piecemeal set of interpretations of the rules that will increase confusion in the marketplace. Wondering if any of you agree with that statement and why or why not. Brent, maybe you can start us off.
Yeah, I don't agree with that. I mean, first of all, if you look at the history of advisory opinions under the FDCPA, there really haven't been that many. The FTC, and I tried to look and see, I don't know, Patrick or Dustin, if you guys checked on this or were able to find a definitive list, but trying to see how many were out there under the FTC. The CFPB has so far only issued one advisory opinion under the FDCPA, and that dealt with mortgage servicing rules. So I'm a little skeptical that there's going to be so many of them that would create the kind of confusion that certain commenters sort of tried to warn about. So I think they're going to provide clarity. I think that, particularly when you look at which I know we're going to get into when you look at the standards for what the CFPB looks at when deciding whether to issue an advisory opinion, I think they're going to issue them and, to try to clear up specific issues that are appropriate for this type of interpretation. And, I think it's going to provide assistance to industry where we can get advisory opinions. And I don't see that it's going to cause confusion.
I think I generally agree with that. The only caveat I would add is that anytime there's a change in the law, advisory opinion is not the law, it's not binding. I suppose there's always room if you're presenting it to different courts, for example, for differences of opinion on how it might apply to certain facts. But Brent, I think you nailed it right on the head. I don't think we're going to have a volume of them that are going to necessitate a bunch of judicial interpretations, largely because they're going to be so fact specific. And I also doubt that we're going to see anything internally contradictory amongst the opinions themselves. Could be wrong, but I'm guessing not. And Brent, to your point earlier, no, I have not found a definitive list of how many the FTC took, but it's just in court opinion after court opinion about how precious few they were and how frustrating that was for stakeholders. And hopefully that won't necessarily be the case here. This is maybe diving into the legal nerdery of it too deeply, but what the FTC had a habit of doing, right, is issuing those staff letters, which weren't actually advisory opinions. So they give you a thought on what the staff considered of your proposed fact situation, but it didn't actually have that effect that Dustin was talking about, where you could actually rely on it and use it as a defense in the lawsuit. Again, based on what we're seeing, I think from the Bureau's proposal back in November, I don't know that that's how that's going to be handled under this new regime, but something to think about historically.
So let's spend some time now talking about what some of the areas you think we might see the industry consider requesting advisory opinions, especially if there's anything related to the debt collection rule. I know one, just to kind of to jumpstart the conversation with respect to the limited content message. If my company name has collections or in it, that's obviously something that you can't use. But what about if it's got recovery or credit or some other word? Is that gonna run afoul of the limited content message as well? I know that's been one thing that's been suggested as a possible advisory opinion. What are your thoughts on that? And do you have any other ideas where you think we might see or need advisory opinions? Dustin, you can start us off this time.
All right, Michael, you took my best one there.
I'm sure you can say it better than I did.
So the one thing I do want to point out in the advisory opinions policy that the Bureau published, they listed what they call weighing factors to weigh the appropriateness of whether they're going to take your advisory opinion into consideration or just ignore it and deny it. And the primary factor there was whether the issue has been noted in previous CFPB exams. And so we all know that the supervisory highlights is a good place to look. The CFPB publishes it quarterly, I think. And you kind of see trends that they're looking at in supervisory exams. And a lot of times, especially in some repossession matters and some personal property notices, things like that, a lot of times what they say is unclear. So I think a good jumping off point would be if there's something you see in the supervisory highlights to bring that up, and you can request an advisory opinion on that. So sticking with that, repossession thought, there is something in the unfair and unconscionable means section in Reg F. When I read it for the first time, it kind of made me pause, and I wasn't really sure what it meant. And as a lawyer, I looked at the commentary and still couldn't find anything. But basically, it mirrors the FDCPA, but it prohibits a debt collector from taking or threatening to take any action if there is no present intention to take possession of the property. And so what the hell is present intention, right? I mean, and a lot of people, when they send these repossession notices, which is required under almost every state's law, when you send that, or even send debt collection notices, right, after the fact for a consumer, who, still has hold of their collateral, hasn't been repossessed yet. Like, what is present intention? Do you have to call the repossession agent the next day to have them pick it up? Does it have to be a week? And that is really unclear when that can be. And I think that would be something that's ripe for an advisory opinion request.
Yeah, that's an interesting one. I thought about this. I'll make a prediction that probably the first advisory opinion that we see will be something. It'll be on something that we wouldn't have thought about today. That's that's a sort of what I expect is going to happen, because I think companies are just starting to get ready to implement these rules and to get ready for the effective date. And I don't think the CFPB is going to. I think there's going to be probably some reluctance to do an advisory opinion on rulemaking that they just completed, that's not even in effect yet, that hasn't been the subject of supervision, has been subject of enforcement. And then, so I think you're really looking at maybe areas of the FDCPA that weren't addressed in the rulemaking, and then why was it not addressed in the rulemaking, and is that something that's subject to an advisory opinion? So I really don't know, what we can expect to see. I think that's why I like the idea that with this new policy, because trade associations are now, because under the pilot policy that was issued back in the summer, trade associations would not have been able to issue requests for an advisory opinion. And now under the policy that was just released, under the program that's in effect now, they can do so. And I think that's going to be, kind of what I would recommend is that you get with your trade association, you get with your fellow members, and you talk about, what are we seeing that is the same problem across the board that really needs to be addressed, and look at it that way.
Yeah, I agree.
Sorry, go ahead,
Patrick.
No, those are, I think Dustin's point about checking and just following the supervisory highlights is a great point. And I'm sort of in Brent's camp as well. I don't know if I can read those tea leaves about what we're going to see. I would expect there will be a large number of folks who might try to use it as a way to vet particular letter verbiage. And I don't know if that's going to pass muster under the various elements for whether the Bureau is going to consider a request or just ignore it and not issue one. So I expect they will get a great deal of emails asking for that type of clarification without giving it. So sort of the reverse of your question.
Dustin, did you want to add anything onto that?
No, I agree with that. And, this is probably a little cynical, but, and I think Brent kind of alluded to this, but the CFPB just spent almost seven plus years developing this rule. I think there's a lot of other, governing laws that the CFPB is concerned about, whether mortgage servicing or fair lending or anything, where they will probably issue advisory opinions first before looking to the FDCPA and this Reg F rule. It's just my gut reaction.
Okay. Another question. Actually, I'm going to hold that question. If any company that's sort of regulated by the CFPB can submit a request, are there any downsides to submitting too many requests? I mean, maybe you can talk a little bit about what you think or what you would advise the decision-making process should be for a company to decide whether or not they want to ask the CFPB for an advisory opinion, under what circumstances or what criteria they should use. Patrick, maybe you can start our discussion this time.
Certainly, thank you. So I don't know that you're going to have a situation again where there's going to be this great volume of accepted requests and you're actually going to get a published opinion. So it's maybe not that there's going to be this rash of them that might be inconsistent or something problematic that way. I think it's more, be careful what you're asking for, right? Because you just might get the advisory opinion published, but it might not be the opinion that you want, right? And so as a litigator, I sort of bring all the world back to some kind of litigation analogy, and this is one. What are you trying to accomplish in an individual FDCPA lawsuit, right? If the plaintiff comes in and they want small money and it's a one-off issue that maybe was a mistake or something, you're more likely to settle that one versus one where it's an issue of, it's existential to your business. There's a revenue generating component. There's a client requirement or something like that. And so you have to press it in court. You have to get some kind of clarification. Maybe there are inconsistent decisions or something like that. So apply those same strategic decision questions to whether you want to seek an advisory opinion. How important is the issue to your business? Are you just asking to know? Is it a narrow? You have to present narrow facts to pass muster with the Bureau, but does it have broader applicability to your business? And if you get the answer that you want, is it actually going to produce the effect that you want, right? If it is a revenue generating issue, if you get your dream, home run opinion, does that translate to increased revenue for your business, or is it sort of a moral victory? So I think it's very similar to game planning, whether or not you're gonna fight a case all the way to trial or an appeal or something.
Brent, Dustin, anything you want to add on top of that, or what you think some of the downsides might be to submitting too many requests, or what the ideal number of requests may be for a specific company, or should they funnel everything through a trade association? Would that be more effective?
I kind of think that having, I guess the answer is I don't really know, but it seems to me that funneling it through a trade association probably is more effective, because then, I think from the Bureau's perspective, when they see something coming from a trade association that is able to say, we've got, this is a great concern across our membership. And, you don't, instead of having multiple requests coming left and right from various agencies on issues, which may be sort of unique or particular to them, as I think as Dustin was pointing out earlier, one of the weighing factors is that it is something of sort of widespread concern, and the CFPB particularly noted things that have come up in examinations. So I think if you're going to because a lot of the people that in this industry, they're not being examined. Mostly the enforcement comes through litigation, so they're just getting sued again and again and again over issues. I think on those type of things, we'd like to see relief. It's probably better to bring it to a trade association, and you could say, well, our members are just getting sued left and right over this ambiguity, and court decisions are not resolving this. We're not getting the resolution through all this litigation, so we could use an advisory opinion on whether X is, violates the FDCP or not.
Yeah, I agree with using the trade association, or even just talk to your lawyer, right, and get your lawyer's advice on what to do. We submit a lot of requests on the state side for either, something as simple as whether a license is required for debt buyers, or, even more substantive questions too. And we try as hard as possible to submit those requests on a no-name basis. I would recommend doing the same thing when you're submitting these requests to the CFPB too. You don't want to put your name out there unless you have a valid, good reason to do that, where the CFPB kind of looks twice at your question and says, well, what are they really doing? And then, somehow there's a supervisory action a little bit later. So, if you were to submit it yourself in your own name, I would just be careful, make sure that's, well vetted.
Right. Yeah. Remember, this is these requests for advisory opinion is really, in that sense, it's a request for permission. It's not a request for forgiveness. You're supposed to be asking ahead of time, hey, if we do this, is it okay? Not, we've been doing this. Gosh, I hope it's okay. Please let us know that it is. And if that's the situation, you definitely want to anonymize it and either, go through your lawyer or go through a trade association. Because otherwise you're just essentially confessing that you've been doing it wrong. If they come out and say, no, we disagree, we think this does violate.
Is there anything to be learned from the first two advisory opinions that came out? One was on earned wage products, and one was on private student loans. Is there anything in reading those that kind of helps you sort of triangulate or better understand, how the CFPB is going to approach advisory opinions?
I took a look at those. I didn't read them because it doesn't really apply to what we're doing, but
Sure.
I took a look at them just because I was interested in seeing how they were doing these. I did read the mortgage servicing one when it came out, but it's been so long since I looked at it that I don't remember a lot in detail. I will tell you, just like most things you see from the Bureau, they take on, and that's why I think these weighing factors are so important. That's like why I think we really need to give a lot of thought into what we're asking for rather than just bombarding the Bureau with requests, because they're not going to take many requests because they really do put the time in to research it, to weigh different. These are very meticulously done. And so if you get an advisory opinion, it's going to be detailed and it's going to be very well done, and they're going to put a lot of time into it. And that's why they're not going to take a bunch of these a year, I don't think.
Yeah, that's the biggest thing that jumped out to me, and especially the earned wage access opinion, was just the level of specificity that the Bureau included in there. Like essentially for a product to be included as an earned wage access product, which it's where employees get their paychecks ahead of their normal payroll date. The Bureau listed, 10, a dozen different factors that your program had to fall in line with for it to be considered covered, or I guess not covered here, under Reg Z. So it wasn't under the definition of credit. Very detailed, very specific. And I would assume that any other request coming from the debt collection industry or anywhere would have to be that specific as well and lay it out for the Bureau to make an easier yes or no answer. I don't think they're just going to take broad questions and then try to narrow it down themselves.
So given, the level of specificity that you're mentioning was included in the advisory opinions, does that mean that there should be a corresponding amount of specificity in the request? Like, how much more does an advisory opinion email have to be than, we're not sure whether or not it's okay to use, our company name. What do you think? What other information do you think is going to have to be included if someone's looking to obtain an advisory opinion on a topic?
Well, the rules require it to be pretty detailed, and because these are fact-specific opinions. I think Patrick was talking about it earlier, the difference between a rule and an advisory opinion. The rule is broad. The advisory opinion is, considering all of the factors for in the requester's situation. They define the requester's situation. So it really is more like a case in litigation. Cases are decided on the facts, those specific facts of the case, and they can vary greatly from case to case. I think the same issue applies here. And that's what Dustin just said is I talked about the level of detail in the advisory opinion, but I think what Dustin was just talking about is that is in large part because of the level of detail in the request itself. And I think that's what the CFPB is looking for.
So let's say you go through the process, you submit a request for an advisory opinion, the CFPB accepts the request or decides, looks at the issue, looks at the request, decides that they're going to issue the advisory opinion, they issue it. What happens then? Like if I'm a company in the collection agent in the industry, do I take that as sort of gospel at that point, or can I use it if I'm defending, if I'm being sued for an FDCPA violation? How do you sort of invoke an advisory opinion, from the agency's perspective?
So if you have like a one-to-one, like it's an actual, you can demonstrate we were relying on that opinion in taking the steps that we took. In an actual lawsuit, it's going to take the form of an affirmative defense, right? You're going to allege that, and then you're going to have to establish it. Compare it to bona fide error, right? You're basically saying, we took this course because you said it was okay, and here's proof that we actually did that, therefore no liability. But I was kind of talking about this before. You might not have the exact one-to-one. Your issue may be similar, but it's not exactly what was addressed. That doesn't mean you can't present it to the court. It's not going to be an affirmative defense anymore. You might just argue, this is how the law ought to be interpreted. See, look at the Bureau, who is tasked with enforcing and creating these rules, says this is how the law ought to work. So go along with them. Not binding, the court's not required to follow what the Bureau says in that circumstance, but it's persuasive. And if you look into the case law, there are plenty of examples where the courts do take a look to see whether it was the FTC or now the CFPB, and what their view was and factored it into their opinion. So it's pretty hefty when you introduce it.
Okay. Got a couple of questions that have come in the last few minutes, so I'm going to ask those and remind everybody, if you have a question for our panel, send it to us through the chat or the Q&A, and we'll get it asked and answered. Both of these are sort of a little off topic from the advisory opinions, but would like to sort of see if you have any insights into them. And the first one is looking at the transition in presidential administration. Do you think that this is going to alter, change, or just do away with the new rules? Obviously, if anyone has any insights into what you think the president's going to do, by all means share them. But if you just kind of have any thoughts or expectations, what do you guys think is going to happen? Who wants to go out on a limb?
What did Yogi Berra say? Predictions are tough to make, particularly about the future.
That's right.
Seems right. There's going to be a lot on the plate of the next administration, I think. So I question how high up the list does this go in terms of being revoked or modified in any significant way. But of course, now that I've said that, the exact opposite is going to happen. From a practical standpoint, I don't know if they scale that mountain, at least not in the first year, but we'll see.
So yeah, my thought kind of goes back to what I mentioned earlier. The Bureau has been working on this since 2013. So that's Cordray era, then whatever the Mulvaney era was, and then Kraninger too. I don't think a new administration is going to come and just rewrite it or do away with it. I mean, they may interpret it differently, and they may enforce it more strongly than Kraninger's currently would enforce it. But I don't think they're going to do away with it. And that's speaking to Reg F. Now, the advisory opinions, I think it's the Wild West, right? This is a pretty new policy. And whoever Biden appoints as the CFPB director, I mean, they can say, no, we're not doing this and walk away from it. I mean, there's nothing that requires the CFPB to do this other than it just being out there. Or they can issue one a year, right? So that's a little different than actually rewriting Reg F.
Yeah, it's going to be hard to prove. I would think that, I agree that with advisory opinions, I think we'll see fewer of them than we would have seen under Kraninger, but there's going to be no way to prove that. But I've already said I don't think there'll be many. But part of the reason I said that is because we're going to have a Biden appointee, and the Bureau is going to be going in that direction. I think the same thing. I mean, I think technically they could scrap the rule, but they did work on it. I mean, this started under Director Cordray, and I don't think that even maybe if it didn't end up in all details the way that they originally foresaw it, I doubt that there's going to be an appetite to scrap it entirely. But I wouldn't be surprised to see them take up some of the particular issues, particularly on volume, contact volume, and things like that in the coming years. But I think we'll just have to wait and see what happens there.
You mentioned contact volume. There had a question that came in asking, what is the current view of first-party collections and the outbound voice frequency limitations?
Well, first-party collections, I think, that continues to be an interesting issue. We talk about advisory opinions. I think it was actually a staff opinion letter, the DeMayo letter, that kind of outlined the FTC's view on first-party collections. I don't exactly know how to address that. It's a pretty broad question, and it depends a lot on the factual specifics. But I think overall, I don't know that much has changed. It's so factual driven.
It's a webinar unto itself.
Yeah, it is a webinar unto itself.
One question: are any of you concerned about Representative Maxine Waters' renewed push to pause all collections until after COVID is over?
I would say, without speaking to that specific lawmaker's view, I think we can all agree there's been a very fluid situation with COVID, right? It has not been a static, predictable thing. And so broad across the board prohibitions like that, I don't think make a lot of sense. Surely there are a number of folks out there who are experiencing job loss or lesser employment and can't make the ends meet and can't pay the bills. But by the same token, there are fortunate folks out there who are making and can pay, and frankly, may even be saving certain expenses by not traveling outside of the house, and while they're still gainfully employed at their prior level. So those folks, I think, may actually have an interest in using some newer expendable income to pay down debt. And so, no, shutting down all collections does not make sense to me. I mean, it's sort of like talking about shutting down the economy. Collections is an integral part of the economy. Can you just pull the lever and say, no, we're done until COVID passes? No, I don't think that works. You just have to recognize we're dealing with a national pandemic. It's a huge public health crisis, but we do have to find a way to balance fundamental functions of our economy.
Okay. I'm assuming, Brent, Dustin, that you both agree with that. Nobody's going to have any strong opinions to the contrary. There's been some interesting conversations going back to advisory opinions. Consumer advocates seem to think that they're not going to be very effective versus the financial services industry, which thinks it is. They will be very effective. Just wondering if you think that back and forth, whether that should deter anybody from seeking out an advisory opinion, or wait to sort of see how, if there are any more that come out, related to the debt collection rule or the industry in general before asking. Like, does anyone want to sort of be the first one to put their hand up?
No, I mean, I think it's kind of expected that consumer advocates are maybe less in favor, and that's certainly what when the CFPB received comments on this, I think consumer advocacy groups were more skeptical about the usefulness of advisory opinions. I feel like when you look at it, though, I mean, advisory opinions are really a compliance tool, so they benefit directly industry, and certainly under 692K, there is that essentially a safe harbor for following an advisory opinion. So it is an industry tool, but of course, I feel like consumers also benefit indirectly by when collectors are able to better comply with the statute and with the regulations. So, but I'm not surprised to see the consumer advocates are a little more skeptical. And I think what they're concerned about is that the CFPB will essentially make additional rules about the FDCPA through advisory opinions that won't be subject to comment, and won't give the consumer advocacy groups an opportunity to come in and say, why that's a bad idea or whatever. I think that's their worry, but I don't put much stock in that concern. It just seems to me that overall consumers also benefit in the long run when debt collectors are better able to comply with the statute and Regulation F.
Okay. Question from the audience. How closely do we need to follow advisory opinions? And do we need to use these specific answers to specific situations in a more broad way to create rules and or policies?
Well, I'll say what Dustin and Patrick are probably also both thinking. Call your lawyer and if you need an interpretation of the advisory opinion, then yeah, I think you would do with it. I would recommend you do with it what you do with any sort of new information in the compliance realm, and either if you have a compliance officer, run it through that system, and if you have compliance counsel, talk to them about it and say, hey, how does this impact what we're doing? Does this change what we're doing here?
Yeah, I mean, we monitor closely the CFPB's enforcement actions, and recently it seems the director has been suing collection agencies or having consent orders with collection agencies at least once a day or at least a few times a week. I would kind of treat it the same way, right? Read those enforcement orders, see if what that collection agency is doing, and if you're doing something similar or something that even sniffs around it, reconsider it. And I think an advisory opinion, you treat it the same way. And even to a lesser extent, the supervisory highlights, right? I mean, it just gives you a better color and a better idea of what the Bureau thinks is important and what's on the top of their list.
The answers are both well said. I agree.
Because the rule technically isn't going to go into effect right now until November 30th, 2021. Do we have to wait until then to start asking for advisory opinions, or can companies start, or trade associations start asking for them now and see responses from the CFPB before the rule actually goes into effect.
I mean, I'll repeat what I said earlier. I think I'm skeptical that they're going to give advisory opinions on aspects of the rule before, they've been able to see through supervision and examination, or how these things are, how the rules are being implemented and where the real ambiguities are. But I could be completely wrong about that. I'm just skeptical that they're going to look at that before the rules are in effect.
Yeah, and legally, I'm not exactly sure if you actually can. In your request, you have to identify the regulatory or statutory provision at issue. Technically, Reg F isn't a regulation yet, right, until it's finalized in a year. So there is some gray area, obviously, but I'm not sure. That does give them another reason not to read it until later.
Right. That's a very good point, Dustin. And I think the other thing, I mean, even if you're asking about the FDCPA itself and saying, well, we're concerned about this section of the FDCPA, if if the rulemaking that's not yet in effect, clarifies in any way that section, then they're probably going to say, well, let's wait. So I'm just skeptical.
A question asking, if you submit an advisory opinion and the CFPB decides they're going to answer that question or issue an opinion, do they let you know, or is there a way to know that, sort of what's in the queue and what the CFPB is working on? Or do you not know until it gets published?
No, I don't think so. There's a lot of unanswered questions that the Bureau actually addressed in the advisory opinions policy, and most of them are around procedures. Like, do we have to answer advisory opinions in a certain amount of time? Do we have to alert people or explain reasons why we did accept it or rejected it? And they basically said we're not going to answer any of those. So I don't think there's any answers to those questions yet.
Right. Yeah, we don't know. I don't think but I suppose it's possible they might let you know, but there's nothing specific in the program.
One last question for our audience. It's sort of a more crystal ball question, or not crystal ball, but just since the CFPB rule isn't in effect yet, is there a chance the new administration can reverse it or make any changes to it before it goes into effect? I know that's kind of been an open question for a lot of people in the industry.
Yeah, I think technically, from just a matter of procedure, agency law, I mean, I think until it's final, they can withdraw it. But I just don't, as we talked about earlier, I don't think they're going to scrap 8 years of work. Since again, this rulemaking took place over multiple administrations.
And then there's the whole aspect of the Congressional Review Act as well.
And the corollary might be the payday lending rule too, right? That came out 3 years ago, and that's still being litigated now, right? They tried to pull back certain parts of it and only have the payment provision. And that's still in court. So, maybe, I don't know.
Yeah.
Okay. Well, I don't see any other questions for our audience, and we're just about out of time. So I'm going to wrap things up. Brent, Patrick, Dustin, thank you so much for your time and your expertise today. Really appreciate you sharing your opinions and your insights with the audience. Thank you.
Thank you, Mike.
Thank you.
All right, everybody. Thanks again to TCN for sponsoring today's webinar. Please go to www.tcn.com to learn more about the company. Thanks to everybody who participated and asked questions. Stay tuned. We've got one more webinar this week coming up tomorrow on time bar debt collection strategies. And then next week, I think I've got 5 scheduled. One Monday, 2 Tuesday, 1 Wednesday, 1 Friday. Next week is also Customer Experience Week. So go to accountsrecovery.net, check out the events calendar, and you can sign up for all of those right now. So I hope you do that. Until then, I hope everyone stays tuned to accountsrecovery.net for news and other information coming your way. And I hope everyone stays safe and stays well. And we'll talk to everybody soon. Take care.